Hi, and welcome to What's the Tea in L&E. I'm Leah.
I'm Fred.
And Fred, today we are going to be talking about traps. Okay, no, not bear traps. We're going to be talking about traps in the employment context. Fred, what is a trap?
Okay, TRAP is the acronym means Training Repayment Agreement Provision. It's basically an employer will provide training to employees, and the employee has to agree to repay the cost of that program in certain circumstances.
So I feel like we see this a lot sometimes in the context of, repayment programs when it comes to like a tuition assistance program. But in terms of training, how broad does it have to be? Or are there any examples where employers are using these traps, so to speak, and courts or someone is analyzing whether or not they're valid?
Yeah, there's an interesting case that's happening right now in Colorado where an employer was accused of violating Colorado's consumer protection law by offering these free training programs. PetSmart was the company, and they were offering free dog grooming training to their new employees. And the cost of the program was about $5,000.
$5,000 to learn to groom. So, but it would seem like if I were an employee working at PetSmart and PetSmart put me through this training program, that wouldn't I be able to use those training skills or those grooming skills at any other employer, like a Petco or something?
You would think so, but according to this suit, the training was not transferable. So an employee who left PetSmart before they had stayed there long enough to where the repayment was forgiven, um, they brought the certificate to a new employer, and it didn't transfer. So it was basically worthless outside of PetSmart.
So the certificate was worthless, maybe not the skills. I don't know. The defense attorney in me is coming out to say, if I know how to groom a dog at PetSmart, I probably know how to groom a dog at Petco. But if you do have a poodle, please take them to both so we can compare these two. That said, okay, so basically, PetSmart was using these provisions that said we're going to throw you through this free training program. You're going to learn how to groom a dog here at PetSmart. You're going to get this certificate. But then if an employee left, they were making them pay it back.
That's right. They were kind of aggressively going after the employees to repay that $5,000 debt if they hadn't stayed for 2 years.
I do think I saw an article where it said 8 of these workers had actual dings on their credit reports because of not paying this back. So aggressive is right. Okay, now how does this really, what can an employer do? Because I mentioned earlier we have tuition assistance repayment programs. That seems like fair game, right?
Absolutely.
If my employer helps pay for my tuition for me to get my master's, and I've got to stay for 2 years, seems like fair game. What's the kind of takeaway then for employers who want to maybe loan employees money or put them through a training program like a police academy? How can employers still go about that and not run into the situation that PetSmart did?
I think the number one lesson is to be clear about the conditions of the benefit. So it is a benefit to provide that training at a cost to the employer, but the employer has to be clear upfront about when it will be required to be paid back. So in this case, the problem was that I think PetSmart was offering the program as free, and in theory, it was transferable to another employer. So if another takeaway is if the benefit is entirely for the employer and not for the employee, they can't take it to the next employer, then it's probably something that you should pay for yourself as an employer.
So you got to look at the substance of the program or the training you're offering, i.e. the benefit and who's actually benefiting from it. And you've got to be transparent. Make sure it's in a standalone agreement. Don't hide it in some long, detailed employment agreement. All right. Until next time, that's what's the tea. Thanks, Fred.
Thanks, Leah.